Hi, everyone, and welcome to another episode of our show, Mending Fences. My name is Charlene Goodman, and we're joining you from the kitchen today instead of the conference room with the Honorable Janine Barbera-Dalli and Al Hedayati of the Hedayati Law Group. Welcome.
Hi, everyone. Hi, Charlene. Thanks for the introduction.
Glad to be here. Thank you.
Judge, you want to introduce us again? Like, not introduce us, but tell everyone what we're going to talk about today, maybe?
What we're going to talk about today is the difference between a legal separation and a divorce. Many couples come into either mediation or come into the law office and really don't understand the difference. So we're going to explain the difference and the procedure and how each procedure works.
And we're going to see Al make some tacos while we do that, and margaritas.
They have me in the kitchen, and I'm doing tacos, but I'm also doing a Mexican specialty drink, margaritas. So let's see how it goes, because the last show, the judge actually gave us the wonderful Italian treat, and I'm hoping that I can compare, but I don't think I'm gonna come anywhere close. Maybe with the drink though. But so I'm gonna just start by blending. Judge, do you wanna start talking while I do a little quick blend with the blender?
Before we delve into anything, I just have one question that some of our viewers might wonder as well. Is there any way that I can protect myself, just in case a divorce happens right before the ball starts rolling? How can I protect myself, my family, my assets?
Are you married already?
Yes.
Okay. Because if you weren't married, I would have suggested a prenuptial agreement, which I say to anybody probably over the age of 25 who has any assets prior to a marriage. And what I mean by any assets, not just a house, not the big assets you mean, but even a pension or retirement. If you work for the state or you work for a federal government, you have a pension. And a prenuptial agreement can stop that from being distributed later on in a marriage that turns bad into a divorce. But we do have another option if you haven't had a prenuptial agreement. The only problem with this is that the timing will also dictate how you negotiate it. So in a postnuptial agreement, which is what you're referring to, you can also put in the paperwork what's going to remain single and separate property and what, I lowered that for you, Al, because it looked like it was starting to burn, so I just wanted to help you out there.
Thanks, Judge.
Anyway,
This is harder than my day job right now.
I understand that.
Trying very hard.
So you can negotiate a postnuptial agreement, but like I said, it's probably not as simple as a prenuptial agreement, because again, you're doing it because you have assets already. And normally, anything that's accumulated during the marriage under equitable distribution is split between the parties. Do you understand what equitable distribution is, or should I do a quick?
Maybe you should tell us all a little bit about that.
Before you do that, Judge, can I just hand out the drinks?
Absolutely.
Real quick, because I
You
wanna.
wanna tell us what's in it?
Yeah, what's in that drink? Yeah.
Sure, so what we have is a margarita, obviously frozen, as I used the blender. So it's got agave, lime juice, tequila, and sea salt. So it's not a very complex mixture, but it's about how you do it. So I'm gonna give it to the office manager and the judge first, and they get to tell us what they think. Please tell me you like it.
You want me to lie to you?
I think it's good.
Ooh, tequila.
I made it look nice too with the little lime. Was looking for
very good.
umbrellas. Is it, Judge?
It's very good. It's very good.
Yes, delicious.
And just realize that none of us are going to be driving right away, so it's okay that we drink this, because
Oh, that's good.
we don't drink and drive.
Did all right.
You did fine.
So go ahead with equitable distribution, because now I can move on to my
Yes.
next job, which is the taco portion. Go ahead,
Did you tell
Judge.
people you were even making tacos?
We are making tacos. Obviously, I had the assistance of Miss Charlene Goodman. I can't take all the credit for this part of it. That part of it, I can take a little bit of credit with the drinks. But the mixture here with ground beef and the taco mix and the meat is done by Miss Charlene Goodman. And obviously, all the toppings are to the right. So go ahead, Judge.
Okay.
Thank you.
Prior to 1985, if you were married and you got a divorce, whoever's name the asset was in got that asset. We didn't have anything known as maintenance, we had something called alimony. And what alimony wound up doing was supposed to equalize whatever that other party's assets were. So usually back then, it was where the husband had all the assets in his name and the wife would be entitled to alimony. The way alimony had been calculated is they would outline, if the woman wasn't working, by the way, outline what the cost was for all of the jobs in the house that she did. So they would apply a dollar amount for her chauffeuring, for her cooking, for her washing. Anything that she did within the household was given a dollar amount. Now, of course, the dollar amounts fluctuated depending on who the judge was or whatever the agreement was. In 1985, that was done away with, and New York became an equitable distribution state, which is very different, by the way, than a community property state. A community property state is what Florida has, and it's what California has. And if you've ever heard the Eddie Murphy skit that he does, she gets half. Yes, everything in a community property state is half, regardless of whose name it's in. As long as it was acquired during the marriage, everybody gets half. That's not what we are here in New York. New York is an equitable distribution state. Now, what does that mean? That means if it was accumulated during the period of the marriage, the court will presume, regardless of whose name it's in, that it is equal, that you get equal. But it's not necessarily so. Because if you can prove that your spouse had nothing to do with the business that you started yourself, say with your father or your friend or your brother, and that party had absolutely nothing to do, she never even stepped foot in the business, and I'm saying he, she, but it's interchangeable, then she may not get anything out of the business. Or she may get something. She could get anywhere from 15% to 50% or zero. Again, it depends on how much the person interacted with the business and what a judge decides. It's very discretionary with the judge. We don't have alimony anymore, so we don't assign dollar amounts for things that they've done in the house. We have something called maintenance. And maintenance is also gender neutral, which means that either party can get maintenance. And who's paying maintenance? The moneyed spouse. The person who makes the most money is going to wind up paying maintenance. That and child support are now in New York by statute. There are formulas that are used. Now with maintenance, the judge still has some discretion as to how much in maintenance, but in child support, there's really no discretion, other than the fact that a judge can put a limit on the dollar amount that the spouse, the moneyed spouse, makes, and doesn't necessarily need to go over that. But there's all sorts of things that they can look at, which is the lifestyle of the parties, how the parties live, the children's understanding of what they would be entitled to. So there's a lot that goes into it, but the most important thing you need to remember is New York State is equitable distribution. Did you want to add anything to that?
I mean, there's so much to talk about. It
Yes.
depends on what particular portion. If you're talking about alimony or maintenance, the laws have changed, as the judge indicated. And you know, there is formulas now, so you can, you know, if you decided that you just wanted to find out what your rights are, we could certainly run the formula and figure it out. Obviously, as the judge indicated, there can be lifestyle, based on your lifestyle, you can have an increased amount of maintenance or child support, but that's discretionary to the judge, and you have to really prove your case. I think that's what the legislature did to kind of clear it up, so it's not all over the place depending on what judge you have. But with that said, I just wanted to tell everyone what I've done with the cooking, and keep the cooking aspect of the show just move it along. So these are the hard shell tacos, thanks to Charlene Goodman, and these are the soft shell tacos. Now, everyone can use whatever they want as far as toppings: lettuce, guacamole, tomatoes, onions, whatever suits your appetite or your palate. We each can certainly try. I think we need some forks and of course salsa and hot sauce, and there are other things.
What kind of meat was used, if I can ask?
I have ground beef. The spices were a little bit of garlic, cilantro, salt, pepper, cayenne, and chili powder.
All right, we're gonna test this out. Judge, which one do you want? Let me get you some plates.
Oh, I only like soft tacos.
Soft?
Yeah,
Really?
yeah. That's all
You're
right.
smart, it's better for TV. I'm gonna get it all over my nice apron.
Well, we're supposed to be talking about, I believe, the difference between a legal separation and a divorce,
Yes.
right? Isn't that the topic for today?
The legal separation and the divorce, and it's interesting, from our first show, if the listeners or the viewers were there, Judge and I may have some difference in opinion, and that's okay. Because as we've indicated in multiple shows and radio shows, you could have a difference in opinion when it goes to an approach or what your take is on a particular issue. Here, Judge and I, the difference between a legal separation and a divorce, you know, generally when people do a legal separation, A, they're somewhat amicable, and B, what my experience has been is that one party may need to continue to be on health insurance of the other spouse. Whether that's for, you know, other pre-existing conditions and health situation, you know, if someone has cancer, you know, to keep her on the health insurance so she can finish or he can finish treatment would be the right thing to do. A separation agreement, just so everyone understands in New York State, would have to be entered into and maintained or kept in for at least a year. After a year, the parties can actually each file what's called a conversion divorce. So you don't have to go through the whole process because the agreement is very similar to that of a divorce agreement. So either party can really file, unless there's a condition in the agreement that says it won't be filed for a certain amount of time, that's a different story. But in New York State, after 1 year of entering into a separation agreement, each party has the right to then go file for a conversion divorce. So it's not a long-term fix. Some people, I've had clients that have maintained it for 5 years and are still under the separation agreement. As far as we know, no one has filed for the divorce. But it's a nice way to not cut ties. I know Judge has to say something. My final words on that issue are, Judge, that the cost of health insurance being so high, I understand there's now New York Health Plus and there's some policies that there's no more, and I'll let Judge speak about the pre-existing conditions. But cost of health insurance is very high. If your spouse is a government employee, whether it is teacher, police officer, fire department, works at the fire department, these are very good insurances, and sometimes they want to keep it for that very premium health insurance, which makes sense because and then that can impact the maintenance. And I'll let Judge elaborate on that because you can certainly negotiate that there as well.
Well, Al and I have a very big difference of opinion. I hate separation agreements. I know that sounds harsh, but there's a reason for it. I've had too many separation agreements come into my office, and one party was willing and the other party said, yeah, you know what, I think I'd like to renegotiate what we did 5 years ago, 1 year ago, 10 years ago. We've had people come into the office who have been separated for 25 years. Inevitably, the parties are not at the same place at the same time. And the only reason that this will go off without a hitch is if they are. And most times they are not. So what happens? You don't have the good fight. You don't have a good fight, which is what I like to do. If I'm gonna have a good fight, I wanna have it once, and I wanna be done with it. Separation agreement leaves the door open for either party to renegotiate whatever's in there. Now, you can say, well, what if I go to court and the judge agrees with me, it's in the agreement? Of course, you can always go to court, but what does that include? What happens with that? What does that include? It includes hiring an attorney, it includes litigation, it includes going to court, it's a lot more money. My idea is you cut your best deal right from the start. You call it an uncontested divorce or, a stipulation of settlement and not a separation agreement. If you're concerned about healthcare, like Al said, that's very reasonable. But let's remember, New York, no insurance company is allowed to deny you for a pre-existing condition. It's illegal in this state. It's part of the Affordable Health Care Act on the federal level, but New York has had it long before that. The second thing is, you're right, it's pricey to get your own insurance. I'm not gonna deny that it isn't, but that can be incorporated into a maintenance award. So if the wife is in the middle or the husband's in the middle of some kind of pre-existing condition and cancer treatments or whatever, that can be incorporated as part of their maintenance award. And the spouse, who is the moneyed spouse, would pay for that coverage for a period of time. That's the way to handle it, in my opinion, to avoid litigation again.
I don't disagree that you're gonna basically have to relitigate again. And one of the best things about the divorce is that you wanna be done with it once and for all. But that goes with other terms in an agreement too. And what I mean by that is, for example, if you own a residence together, property, a piece of property, these things, you could always have post-judgment issues. I don't disagree with Judge at all. When we do a divorce, we rather everyone move out by a certain time, finalize everything by a certain time, so there's finality. But a lot of these cases, especially with the mortgage rates right now, Judge, people cannot do a refinance to buy someone out of a house. So we're kind of punting in these agreements right now, I have to say, because we're punting the issue to later, because right now with the interest rates being over 7%, even though the Fed has told us it's gonna come down in 2024, people enter into an agreement, and when both names are on a mortgage, the only way to remove one party, if you're agreeing that one party will buy out the other party's interest, the only way you can do that is to do a refinance. I don't know, I haven't had one case, and we have plenty of cases, where anyone is happy about a refinance or they're willing to commit to it. So what we typically do in agreements is we extend the time for like a year, 12 months to 24 months. If the opposing side is friendly with you, they may give you that much time, but generally speaking, they like to get that done within 6 months. And I don't think anyone is comfortable signing it. Same thing with a separation agreement. When you have agreements, people have to adhere to the terms or you'll end up back in court. So what Judge is saying, and I'm saying, is we both agree that the best thing to do is cut ties. Don't have one person lingering in the house for 90 days until they move. Like, we can do all of that while we're negotiating terms and mediating the agreement. So by the time everything's done, you're signing today, you can be out or separate or list the house for sale. There's so many factors that Judge and I are both in agreement that we want them to finalize, but it depends on, like we always say, the facts and circumstances of that particular case, because I think you have to do that. But anything else to add, Judge?
No, the overwhelming issue is.
Hold on, Judge, did you take a bite?
I did, it was very good.
Was it very
It
good?
was very good,
What was the best part, the margarita?
the margarita.
No, I'm just messing with you, Judge. Charlene, it's delicious.
Very
Right
good.
amount of
Good
all the
job.
spices, thank you so much.
You can prepare my next show if you want. The most important part of this is to tie up as many loose ends as you possibly can. It's so that you don't have to come back to relitigate any of these issues. And there are a lot of issues that you can tie up in advance. And like Al said, so you can't refinance this week or next week or 6 months from now. You put a time limit in there, and it's a drop dead time limit. That's what I like to put in, the drop dead time limit. I can give her another 6 months, or I can give him another 6 months, but by 18 months, if this house is not refinanced, it goes on the market for sale. That's it, no ifs, ands, or buts. And there's not a judge in any county that is going to say you were unreasonable in doing something
No,
like that.
they're always gonna sell the house, just so everyone is aware. I use this house as an example, but the only power a judge really has, even though I've seen in other circumstances, like we always say, it depends. You know, that's a very lawyerly response, but it's actually true. It depends. Judge's only power is to sell the house. So if someone doesn't do it within the 18 months, you know, then the easiest thing would be list the house immediately and sell the house. But then someone could not leave the house. There's always something else that can really drag on any case. But the best thing to do is cut ties if it's a mediated agreement, and just make sure everything is, like you said, a drop set date so that everybody knows.
If I can just interrupt for a
You
minute,
could
Chris.
always interrupt me, Your Honor.
You're very sweet. What I wanted to indicate is when you said the only power the judge has is to sell the house, that's after a divorce is final. A judge cannot force a
That's right.
sale of the house prior to the finalization of a divorce. Okay, and people ask us that all the time. Well, I can't afford it, so he's gotta force the sale of the house now. It's not gonna happen. It's not gonna happen. No judge is gonna do that. No judge can do that.
Yeah, so I'm gonna tell a story.
Go ahead, tell a story.
I have two cases like this as we speak. On one case, the spouse had signed, and I'm using spouse instead of husband and wife, so people don't think we side with one side over the other, it makes no difference. But in this particular case, the spouses both had signed a listing agreement with a realtor, and then she removed her signature, wrote a letter to the realtor and stopped it. That's absolutely correct. During the pendency of a case, neither party can sell the house. And with the economy or specifically the housing market slowing down, it's not dead at all, but there's not enough on the market, so values are still high. But it's a lot slower than a year and a half, 2 years ago.
Just to make clear, they can sell it if both parties agree.
I agree, yeah. By agreement only, but neither one of them can sell it basically exclusively or alone. Even if the house is in one of the client's names,
That's right.
it makes no difference. But the whole point is, again, it goes back to all the different factors surrounding a lawyer's decision. You know, the markets, the interest rates, you know, and who's gonna get out of a 3% rate. That's the situation I have. They have a 3% interest rate on the house, Judge, and now whoever, so the only thing I say, just sell the house, cause there's no other option. You know, if you're not gonna, the rates may never go, never say never, but the rates may not go down to the rates that we had a few years back. So if you're not willing to refinance because you're stuck on this 3% and you're saying to me as a client, but I'll make sure I'm on time with all my payments. But you have to understand, if your spouse's name is on the mortgage, they're gonna be carrying that on their credit, which means they can't do anything with their credit. So it's not the fair option. Even I won't even propose it to the other side because it's not a fair option. Because I know what it's gonna do is end up in litigation a few years down the line, and that's why I said you're basically punting a problem to a later date, which both Judge and I are in agreement, we don't like to do. We like to get it over with, move on with your life. One more thing, Judge, you said, we never know what's gonna happen. Guess what? Both the spouses are gonna have a boyfriend, girlfriend, get remarried. I've hardly ever seen where the new person in their life is going to be, oh, okay, you still have your ex-wife is still living in the house and it's still on your credit, so we can't purchase a new house. Like, you just have to be very reasonable and use common sense.
Speaking of that, I also don't like nesting agreements.
Oh, the worst.
Let's touch on what that is.
Explain what the nesting
A
is, Judge.
nesting agreement is where both parties agree to stay in the house for a period of time. And one party will move out for a week and then the other party will stay there. It's mostly to facilitate a custody arrangement with the kids. They're horrible. It never works out because you always have somebody who wants to bring a girlfriend or boyfriend into the house, you know that. Or, well, they're not here, so I can bring my significant other into the house. It never works. You need to be physically separated, and that means completely physically separated. Nesting agreements are fine for a very short period of time during the pendency of the action. I will agree that can work during the pendency, but once the divorce is final, you gotta move on.
We agree. I don't even like him during the pendency because what it does, it creates an unreasonable expectation. And we're not talking about children right now, but the times that I've done nesting, the other sides, which I always try to advocate against and not allow my client or advise my client, because the clients ultimately decide what they want us to do. So, but we have to do our best to make them understand the consequences. 9 out of 10 times we're correct because we've done this before, we've seen it before, and we know what the future may hold. A lot more than a lot of spouses. So, cases of domestic violence, Judge, it makes it so hard for us to represent the client in that they fail to listen to us because they've been under the control of their spouse for so long, they still listen to the spouse.
Yeah.
And I've had this situation where the spouse wanted a nesting agreement because the kids, it's for the best interest of the kids. Well, you're gonna get divorced, probably a good idea for both parents to sit down with their children and speak as one, right? You wanna be a united front when you're speaking to your children about, look, there's always gonna be one mom and dad, and no one is gonna replace this person. But look, we've decided to go in this direction, and the bottom line is we'll both love you, and that's it. You have to have that conversation. But the point is, these nesting agreements, I've only had the pleasure of, understanding them better and better in those domestic violence cases when they're kind of forced on the other side and they just say yes because they've been saying yes to their spouse their whole marriage. And it's very hard to represent them because, like you said in our previous show, we're not therapists. You're not paying us to be therapists.
That's what I was just gonna touch on. Rule number 1, get a therapist.
Yeah.
You can hire an attorney, but get a therapist first.
And we're not trained, so it's not, I know a lot of people may think, oh my, well, he said go get a therapist, we're not trained to do it, we're attorneys, we don't know what the therapist's techniques and what they've been taught through their education entail in order to help the person that really needs the help. So, again, we go back to every case is very fact specific. We would like to sit down with whoever has questions, our listeners, our viewers, And again, it's always a free consultation, and the reason for that is we don't even limit our free consultations, Judge. That's one more thing that I wanted to touch up on, is I've done consultations that take 2.5 hours. I know other offices and firms have a half-hour free consultation. We don't do that. We have to know the whole case before we can properly give you our opinion and advice.
The other thing I wanted to touch on, for all you viewers out there, if you do have any questions that you'd like answered in future shows, you can email us. The emails are at the end of the show on the credits. Email us your questions. Maybe you're not the only one who has a similar question that you want answered. We'll do our best to answer all the questions in our next show. Wow, Al,
Do you
that
wanna
went really
do-
fast, Al.
It does go, these shows go
It
fast.
did.
Well, it means we're having a good time and
Is
we
that
have a
what it
lot to
means?
talk about. But what would you like to say in closing? Because I've always listened to the judge, so she knows. We've known each other for some time, but
Well, what I wanted to say was, I hope you enjoyed us cooking for you in the kitchen. I enjoyed Al cooking for me in the kitchen, that was fun, and I enjoyed his drink, that was fun. And I thank Charlene for her assistance in all of
Thank
this. Is there anything you wanted us to touch on at the end of the show?
No, I just appreciate that you've really broken everything down for people who aren't familiar with this process, because I know if I found myself in this situation, I would be very frightened and intimidated, and it's nice that we could kind of bring it here from a less intimidating room than our main conference room. But you can still feel free to come and see us or give us a call or an email like the judge said if you have any further questions. Thank you.